Hi, fellow classmates. I'm Chris Weberly, and I'm providing a presentation on HIPAA privacy considerations. HIPAA privacy considerations, or what might be called the privacy rule, is its own section of HIPAA. It came into effect as of April 14th of 2003. The privacy rule, in general, it regulates the use of protected health information, specifically for covered entities. These entities include healthcare clearinghouses. This is an entity used to process or aid in the processing of health information. Another entity are health plans, so that would specifically be insurance, group health, and then also medical service providers, so doctors, counselors like you or I, things along those lines. The privacy rule was established basically to set up to create a set of standards for the protection of certain health information. It was created to assure that individuals' health information is properly protected. It was created to make sure that there was still a flow of health information needed to provide and promote high-quality health care. It was created to afford protection to the public's health and well-being. It was also created to give patients control over their health information. It also was created to define boundaries for the use and disclosure of health records by covered entities. It also establishes national level standards that healthcare providers must meet. It limits the use of that PHI, that's personal health information, and minimizes its chances of disclosure. It creates a system that investigates and holds accountable violators. And it also supports the cause of disclosing PHI without individual consent for individual healthcare need, public benefit, or national interests. Breaking it down into kind of four main areas as best I can. I took Kay's lead on this, and she had provided a presentation earlier in the semester about HIPAA, and she had broken it down into four areas, and I like that because it was there's a lot of information. So in breaking down the privacy rule into four areas, it's mainly who oversees it overall, it's from the government, a designated, so the second part is a designated privacy officer. Third part would be how confidential information can be used and disclosed. And the fourth part is the patient's rights covered under the privacy rule. So that's four areas: who oversees it, the designated privacy officer, how confidential information can be disclosed, and the patient's rights. So who oversees it? That's the Health and Human Services Office for Civil Rights. They started doing that in 2009. And if there's ever a violation, that's also to whom we report. As far as a designated privacy officer, every specific organization or healthcare provider has to have a designated officer. They don't have to be exclusive to this. They can do other roles, but they have a certain level of standards they have to meet and requirements they need to have. One being they need to be certified with being able to do that with the Healthcare Compliance Association. This person oversees all ongoing activities related to the development, implementation, and maintenance of a place's privacy policies in accordance to HIPAA requirements. And you can imagine that includes a lot of different things, such as making sure notices and materials stay up to date. They oversee training. They have a method of tracking privacy practices. They have to handle complaints and do the follow-through. They also interact with the authorities related to the privacy rule. The majority of the rest of this presentation is going to focus on the last two areas: how confidential information can be used and disclosed, and a patient's rights. So, examples of how confidential information can be used and disclosed. Any information considered PHI, that's personal health information, is protected. So this includes a person's past, present, and future medical and mental health treatment, and their health and their treatment. It also includes any payments towards any past, present, or future treatment that they may have had or receive. When it comes to disclosing information, you can disclose health information as long as there are no identifiers. That means there's a term for it called de-identifying information. So as long as health information is not identifiable to a specific person, it can be disclosed. There's more to it than that. As far as when can you disclose PHI, when there's a required disclosure. When an individual asks for his or her PHI, that would be one. When there are permitted disclosures, so when the person who that information belongs to requests it. When there is treatment, payment, and healthcare operations involved. When there's been written permission obtained, what we call a release of information, or ROI. With all that, though, within the permitted disclosures, there is sort of a rule of thumb that we are required to follow, which is called minimum necessary. That basically means, as you can imagine, disclosing the minimum necessary. Also, disclosures can be made. There are some times when disclosures can be made without permission. This concludes in the context of when there are victims of abuse, neglect, or domestic violence, when there's a court order, when law enforcement are requesting it, organ donation, when there is a serious threat to health or safety to others, and to comply with workers' compensation laws. So, as far as examples of patients' rights, every entity must provide notice of its privacy practices not later than the first service encounter. So when we first meet with someone, they are to be provided, written out, the privacy practices. And they also must be able to have shown that we must be able to document that they have received that in some form or fashion. But it also must be posted somewhere where someone just walking in wanting to investigate what kind of services may be available at this place, it must be posted in a place where even they could see it, even prior to meeting with somebody. Patients and clients always have the right to access their PHI. There are a few exceptions that I listed on the handout. Patients always have the right for amendments, specifically when there is inaccurate or incomplete information. When there are confidential communications involved, patients have the right to require maybe different ways of having that information delivered to them, as long as they are reasonable. As far as violations are concerned, not all violations are violations. There's a difference between incidental and accidental. So one of the things that HIPAA protects you or other healthcare providers is with a term called incidental disclosure. Incidental disclosure of PHI is not a violation of HIPAA, and it is in fact permitted. Incidental disclosure includes, but is not limited to, the byproduct of another person, permissible or required use of disclosure, unlimited disclosure that cannot be reasonably prevented. Also, these are under the assumption that the entity has applied reasonable safeguards and implemented the minimum necessary standard. When there has been accidental disclosure of PHI, every breach of information has a risk assessment to determine the probability of that compromise. So some of those questions or criteria that would be used in that scenario would be the nature and extent of the PHI involved, including types of identifiers and likelihood of re-identification. The unauthorized person who used the PHI and to whom the disclosure was made, whether the PHI was actually acquired or even viewed, and the extent to which the risk to the PHI has been mitigated. What to do if there has been a breach? You need to tell your supervisor, and the designated officer needs to be obviously briefed on that. There must be a notification to the affected individuals. The notification must be provided no later than 60 days following the breach. If the breach affects 500 or more individuals, entities must provide notice to prominent media outlets serving the state or jurisdiction. The entity involved must notify the secretary, which is the HHS, no later than 60 days after the end of the calendar year. Unless affecting 500 or more, then it must be within 60 days of the breach. Obviously, when it comes to this information, I don't need to already say it, but the client is free to disclose his or her personal information as he or she pleases. The idea is that the information, as far as the information, it belongs to them and not us. So they are only sharing it with us with the intention of them receiving and expecting and communicating our help. We are simply stewarding something that doesn't belong to us. So obviously that covers it. Go ahead and take a look at the handout as well. There's several websites that are included on the handout. The one that I found to be the most helpful was the Health and Human Services website, which they obviously oversee the privacy rule, and so there is exhaustive amount of information in there about it. So thank you very much. We're almost done.